Hello and welcome to episode 45 of Not Reserving Judgment, a podcast about the latest intrigues, outrages, and triumphs in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Baron, executive director of the CCF.
In today's episode, I'm going to tell you about a case that will force the Supreme Court to grapple with the question of when police can go onto a person's property without violating their rights.
I'll explain the legal controversy in Quesnel, British Columbia, where the mayor is pushing back against sanctions he's facing for promoting a verboten book.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that did not quite land. But first, I'll walk you through yesterday's 98-page injunction decision explaining why pro-Palestinian protesters must dismantle their camp at the University of Toronto. So this decision came out yesterday around 4:30, and at 4:30, the three of us were like furiously texting, where's the decision? What's the result? And then shout out to listener of the pod, I'll just say GK, who got us the decision, toot sweet. So the decision is a victory for the University of Toronto. Justice Conan of the Ontario Superior Court granted U of T the injunction that it was requesting against Occupy U of T for Palestine, and the pro-Palestine encampment has until today, July 3rd at 6 p.m. to dismantle or face consequences. We'll talk a little bit about what those consequences may be. So right off the top, this was not a case that was decided on the basis of anti-Semitic, discriminatory conduct or expression, nor threats to violence. Justice Conan went through some of the allegations and evidence, much of which, as Josh and Christine broke down last week, was hearsay evidence. But the judge did not find that there was compelling evidence that the encampment was either violent or anti-Semitic. He broke down the terms from the river to the sea, and found that it was not inherently anti-Semitic. I think this didn't end up being the basis of the decision. I will say, as you guys noted last week, things like the red inverted triangle, which were all over the encampment, which is known to be a symbol of Hamas resistance and connected to Hamas's footage that indicates a target that's about to be killed. There were also one of the encampment's guidelines for people in the encampment was that all messaging should be pro the right to resist, which I know from reading and sort of seeing the discussions within the pro-Palestine movement does explicitly encompass things like October 7th. The protesters also posted on social media an image of the president of U of T, who happens to be Jewish, with these sort of like devilish, contorted, bloody hands. Obviously, U of T's president is not involved in any armed conflict, so this was very clearly invoking the blood libel trope. And Justice Conan says, well, they're young idealists in their 20s, so I'm going to kind of wave this away. And I'm not sure that that's the best approach or an appropriate approach. He also goes into, so I've noticed in sort of pro-Palestine circles on Twitter and on Instagram, there's been a lot of celebration, which, by the way, seems a little weird to me that they're celebrating. A judge said we're not anti-Semitic. Yes, and we can go, like, it just seems really odd and sort of to beg the question. But in any event, the judge doesn't exonerate or deny that hate speech was going on, including chalk sidewalks that said, we need another Holocaust, death to the Jews, you dirty effing Jew, Itbat El Yahud, slaughter the Jews. So a lot of nasty stuff. And this was kind of not part of the judge's considerations because it was right outside of the walls of the encampment, but very clearly connected to the encampment and its spectacle. But in any event, this was not required for the judge to rely on in order to grant the injunction. This didn't end up being the basis of his decision at all. The basis of the decision was pretty boring, bog standard property rights under the ordinary statutory powers of the Trespass to Property Act, well-established legal principle that protesters who don't have lawful excuse nor permission, effectively appropriated private land belonging via legal title to the University of Toronto. They also prevented other people from accessing it, whether to counter protest or whether to just sit in the oasis of green space in the center of downtown Toronto, that is King's College Circle. The judge also discusses evidence that the protesters, to add to the point that they were effectively preventing other people from accessing the space, there was evidence that the protesters admitted to that they had implemented their own sort of internal security system, acting as gate marshals. And Christine, you experienced this yourself. Christine wrote a blog post about her visit to the encampment, which will link in the show notes. So there was a screening process where they would ask visitors where they were from, how they heard about the encampment, sort of to try to suss out if they were likely to be adversarial. But also it has to be mentioned also to see kind of if they agree with them. So it was a sort of ideological screening as well, although they said they would allow Zionists in if they were open to discussing. But clearly they were calling the shots. They were treating this as though it was their castle. And U of T's response to this was, well, if you guys can enforce your rules and procedures ostensibly to reduce the risk of escalation, how can you claim that U of T can't enforce its own procedures to do what it sees fit? And the protesters responded to this very clear precedent about the Trespass Act, claiming that these rules do not apply where the property in question was public property, as they claimed. They claimed this was quintessentially public space, or where there were free expression issues. But the judge very flatly and definitively rejects this claim. There is no precedent or principled reason why a free expression claim can oust a trespass claim. Like, there's never been a case where somebody has said, I have such a strong claim for my free expression that I can override your right to use your private property as you see fit. On the balance of convenience, which is the legal test for granting an injunction, the judge put a lot of weight into the fact that U of T was not asking the protesters to stop protesting. They were not limiting the scope or content of the protests at all. They were merely asking that A, they don't live on campus, they don't encamp there, and B, that they don't protest between 11 p.m. and 7 a.m. because I think there are students who live in a residence on the campus, and in any event, it's they're fairly reasonable limit to not have protests going on all night. But they were still allowed to protest freely, essentially anywhere they wanted on campus. So to the judge, that put the balance of convenience on the university's side, because the rights of free expression, even if violated, were reasonably limited. And this raises the last sort of substantive issue that I'll touch on very briefly. And I should mention I have more extensive discussion about this in an op-ed that's going to be out in the Hub tomorrow, which is, does the charter apply to the University of Toronto, which of course receives public funding and broadly serves what we would call a public function in education? Now, this is somewhat of a confusing area of law. The Supreme Court has said that just because an institution performs a public function, that doesn't mean it's government, and it doesn't mean that the charter applies to its actions. And in a specific decision from 1990, about universities called McKinney versus Guelph, the court also found that Ontario universities are not state actors because they are legally autonomous. They have their own governing bodies. They manage their own affairs. The government does not exercise effective control. In any event, and there's some more wrinkles in this issue, which I get into in my op-ed, Justice Conan essentially found that the charter doesn't apply, although he brought into account charter values, which is a sort of famously gray area and confusing term, but the sort of principles of the charter weighed into how he balanced the competing interests of the university and the parties. But he did a fairly thorough analysis that even if he was wrong and the charter applied, he did an alternate charter analysis that found that the rights to free expression of the protesters were violated, but it was in accordance with principles of fundamental justice and the restrictions that the university was placing on them constituted reasonable limits. And the last thing I'll just say about this, Justice Conan has a sort of pithy line about the interests of people who just want to sit on the quad and eat breakfast. This became a sort of shibboleth at the hearing, as Christine and Josh mentioned. The protesters and their counsel took great offense and brought up many times the offense they took at the transposition of a professor or a student and their right to eat breakfast on the quad, and transposing that with the imperative of ending the war in Gaza. And this was really emblematic of the righteous indignation of the protesters. It seemed like, from a lot of their comments and conduct, that they felt that the righteousness of their cause, what they perceived to be the urgency and moral clarity of their cause, should indeed allow them to do away with property rights, do away with the rule of law, do away with anything that we can consider as reasonable limits on their expression, including everybody else in the university community, other students who needed to sleep, Jewish students, for example, who found it to be offensive and harmful that there were people saying slaughter the Jews on the perimeter of the encampment. And Justice Kaye says, well, look, people who want to eat breakfast can eat breakfast. People who want to protest can protest. As much liberty to one as it does not infringe on another person's liberty. And I think this is significant. I think if the decision had gone the other way and held for the principle that somebody's moral claim could completely supersede any type of sort of accommodation of other people, it would be a pretty dangerous precedent. So last thing I'll say, we'll see what the Toronto Police Service do. From what I understand, the protesters have said they do not intend to leave. We'll see if they have a change of heart by 6 p.m. today, which they are very welcome to do. They could relocate to Queen's Park, but the Toronto Police Service tweeted last night that they plan to enforce the court order. So TBD, we'll see what happens. But on the whole, this strategy of holding the university ransom has failed, and rightly so. Josh, what were your thoughts on this decision?
Well, I think we should all feel a bit vindicated because we've been talking about this for a few weeks anyway, and the judge basically agreed with most of our analysis, about whether the charter applies and the implications of trespass and all of this stuff. So that's nice to feel vindicated a bit. I also think it's important from sort of a property rights perspective that people are allowed to control what goes on their property. And I was watching the press conference yesterday where one of the protesters' lawyers, the occupiers' lawyers, basically said the only thing the judge could find here to hang this terrible injunction decision on was property rights and trespass, and people are always using property rights to prevent us from doing what we want. And I just think it's ironic because the main complaint that a lot of these people have is they claim, Israel is somehow illegitimate because some people that are now referred to as Palestinians were supposedly forced to, either sell their homes or to move. And this is sort of the root of all of their offense, is rooted in property rights. So I don't know how they can also claim that property rights are bad and that people should just be allowed to do whatever they want in a public space where the university has really good rules to try and balance freedom of expression with other people's rights, like the right to use the property to eat breakfast. So I thought that was kind of funny. And yeah, you get into your op-ed a bit, so I won't dwell on it, but the best argument they had was that this 2018 freedom of expression directive from the province somehow means that the charter applies to decisions regulating their public space, and the judge said that it does not, and I think that's correct. So that's good to see, but at the same time, it doesn't mean freedom of expression isn't important on campus, right? It's a core value of universities, and it's really important that people can put forward controversial ideas on campus. So even if the charter doesn't apply, I think that's still a really important value to push and to try and protect. And people should be able to have a really wide range of opinions on campus. So those are my main thoughts. I'm probably going to write about this a little bit, so I'll have more to say. Christine, what do you think? You were just at the encampment. It was a bit of a letdown, I understand.
Yeah, what's gonna happen to the olive tree? They have all of these art installations inside the encampment, including this. They said it was an olive tree they're making out of paper mache in progress. My observation was that this was more like an olive stump. That if you've ever seen an olive tree, they're not that big. Like
No.
this was as wide around, like wider around than a full-grown oak. So presumably if they're going to finish building this paper mache olive tree, it would be the size of an oak. And they did not have the people to complete the olive tree or the resources to build the olive tree, just as they did not have the people or resources to run this protest on the day that I visited. So I visited on Friday afternoon. It's like a beautiful day. And when I finally talked my way inside, and I think that they only let me in because I, kind of confessed that I occasionally write op-eds. So they brought their media person out after making me wait an hour and a half. So I think I was let inside because I said I sometimes write for the newspaper. So they gave me this tour and they showed me their olive tree paper mache. I counted maybe 10 people inside. Let's be generous and say maybe there were 5 hidden away in the tents. But it was pretty empty. And they were very desperate to explain the emptiness. They said people weren't there because it was going to rain. I will note that it was a cloudless sky and a beautiful day. So I don't know what on earth they would have done if it had actually rained. So there would maybe be even fewer people. So maybe max, counting everyone inside and outside, 20 people. So I assume that now that the injunction decision is out, they've, called in support for their battle, and they're going to have some altercations with the police, which is not ideal. One of the things that stood out to me when talking to the protesters was I wanted to know what their plans were, either if the injunction was granted or if it was denied. For the most part, no one would tell me what their plans were. I mean, fair enough. You don't have to. You're free to speak to me if you want. But one thing someone said was whatever they decided would be a collective decision, which is a little disconcerting because criminal consequences are not borne collectively. They're borne by the individual. And depending on what happens, if enforcement happens, like depending on how you conduct yourself, you could end up with criminal charges, and that can have lifelong consequences on your ability to travel, your employability, all kinds of things, which are borne by you as an individual person, not by the amorphous U of T Occupy collective for Palestine. So it will be interesting to see what happens. The police are going to enforce, and rest in peace, the olive tree, I guess.
All right, so I think that's enough about that. Let's move on to our next headline. So I imagine a lot of our listeners are familiar with this story, but here's the background for those who aren't. So one of the best-selling books in Canada right now is a controversial book. It's a book of essays entitled Grave Error: How the Media Misled Us and the Truth About Residential Schools. And these essays basically make the argument that the media has created a false narrative about what happened at residential schools, and in particular what happened in 2020 when the country went into a paroxysm of grief over the discovery of 215 possible unmarked graves in Kamloops, which of course led to Orange Shirt Day as a national holiday. The flag was at half-mast for months. Statues were toppled, churches burned. It was a really big deal in our history. And this started when on May 27, 2021, Kamloops chief Roseanne Casimir issued a press release announcing that ground-penetrating radar had uncovered, quote, preliminary findings of, quote, remains of 215 children who were students at the Kamloops Indian Residential School. And this got reported as a discovery of mass graves by media, including ones we're supposed to trust, like New York Times and CTV. And Casimir corrected herself quite quickly, saying this was, preliminary findings, and it was unmarked graves, not a mass grave, which is still very sad if it's what happened, but it's different from the mass graves, which suggests some sort of, mass murder or, purposeful genocide of children, which is one of the most horrifying things you can imagine. So there remains this dispute now about whether these are even unmarked graves or something else. One theory is that what the ground penetrating radar found was drainage tiles, and there's been some investigations going on, millions of dollars spent, and we don't know what those investigations have found yet because it hasn't been released publicly. But that's sort of where we're at with the whole graves story. So back to Quesnel. So this is a small city in northern British Columbia, about 23,000 people, right next to the Lataco Dene Nation. And the mayor of Quesnel is in big trouble, and what he appears to have done is recommended this book, Grave Error, to at least a couple of other people, and he seems to have suggested at some point that it should be available in the public library. Local First Nations people say this amounted to residential school denialism because of some of the claims made in this book. And piecing together the facts from media reports isn't easy, but here's what we know. So in British Columbia, municipalities are governed under what's called the Community Charter. And according to Quesnel's city manager, this provincial law allows for discipline of councillors as long as the discipline is done in like a procedurally fair way. But it doesn't allow for removal, which is what a lot of people were calling for. And, procedural fairness generally means two things. You have a right to an unbiased decision maker, and you have a right to be heard, including getting proper notice. And the city manager also noted that this Mayor Paull is his name, Ron Paull, owed duties and responsibilities based on his oath, and that he could be censured based on that. So here's sort of the timeline. On March 7th, the mayor was informed that his wife was distributing this forbidden book and that this had upset members of the Lataco Dene Nation. And during a council meeting on March 19th, the mayor addressed this, saying he had seen this book in his house, but he hadn't opened it, and he blamed his wife. Classic politician move. Around that time, though, he also told CBC that he didn't agree with his wife on everything. And he said, quote, "You'd love to be a fly on the wall. We get to talking about things like First Nations, residential schools, COVID, Donald Trump, but at the end of the day, we're still best friends." But then during an April 2nd, 2024 council meeting, it was reported that the mayor himself had attempted to distribute this book at a Caribou Regional District meeting, so at a place where he was representing the city. And this appears to be true. It's been reported to newspapers by a couple different people. And so that same day, the Lataco Dene chief told Quesnel Council that he had a problem with this. We can't have a community that hands out hate literature, is what he said, and expect people to listen to us and take us seriously. So on April 18th, the city was sent a resolution from the Band Council stating that they won't work with the mayor and that he's banned from their lands. And this led to censure at a May 2nd council meeting. At that meeting, the mayor apologized. He said he was sorry for, quote, picking the wrong book. And he says, "I did it, but as I said, I was simply not distributing and handing out the book to anyone." So he gets sanctioned, and his sanctions include removal from committees, removal of his travel budget, which we all know is the thing that's going to hit the politicians the hardest. And they demanded that the mayor issue an apology, which he sort of already did, although he was claiming he didn't hand it out at this meeting. That seems to be in dispute. So we now know the mayor is suing council. He's seeking judicial review in a BC court, alleging that the actions taken by council were unreasonable and breached his duty of procedural fairness, and he wants to be reinstated on the committees. He's basically saying he was ambushed at a meeting where various people were invited to denounce him, and this was unfair. So there are obvious parallels here between our case involving John Robertson, the councillor in Murray Harbour, Prince Edward Island, who put up a sign on his private property last September that said, "Truth, mass graves hoax, reconciliation, redeem Sir John A.'s integrity." There's also some big differences here. In John's case, this was an attempt to also push back against the media narrative, which increasingly in some ways does look like it's wrong. And in John's case, like in Quesnel, there was an attempt to force an apology. And even more egregiously, in John's case, the province tried to force him to resign, which is not what's happening here in BC. Another difference here, obviously, is that if it does appear that the mayor and Quesnel tried to hand out this book at an official meeting, and at the end of the day, I don't really see anything wrong with the mayor recommending a book to people. But if it's a defensive book, I also don't see anything wrong with his fellow councillors speaking out and denouncing him for that, right? Where I do have a problem is where we start taking away people's official duties because they're elected, and at the end of the day, they were chosen by the people to represent their community, and it should be the people that removes them if they think what they've done is so offensive. And look, you know, at least some of the authors in this book, they do take positions that I think are just plain wrong and that I don't agree with. And so I understand the anger about this. Like, it's true that maybe some First Nations learned useful things in residential schools. That doesn't make up for the fact that people were, parents were forced to send their kids to these schools where they couldn't speak their own languages, where they couldn't see their families for months on end, where they faced sexual and physical abuse in some cases that we know goes on at these types of institutions. And all that said, I think it's important that we do know the truth about what actually happened in CanLII. And I do worry when media jumps to conclusions or gets things wrong. And so, we need to have like a common set of facts on these types of things if we really want to move forward on truth and reconciliation. So I think there's a lot of work left to do. It's interesting to see what's happening in CanLII. And that's sort of my thoughts and my update on the story. Joanna, what are your thoughts on this whole thing?
Very, very few thoughts, except to reiterate that I totally agree with you. A mayor is entitled, whether it was him or his wife, to recommend a book. His colleagues are free to denounce him. I haven't read Grave Error. I actually would like to read it, and I'm more curious to read it now. Because my understanding was that it was mostly around the botched investigation around the graves, but it sounds like parts of it are also about residential schools. I know Tom Flanagan, he's obviously a very polarizing figure. But yeah, if you're democratically elected, then let the people vote you out. It's the same thing with Sarah Jama, who was kicked out of caucus, properly so, but still elected to her people. She was, of course, somebody who made some offensive post-October 7th remarks. It's the same issue here. I don't know. What do you think, Christine?
I think it sounds like Josh may have read the forbidden book. He sure sounds like he knows a lot about it.
Somebody sent it to me, and I've started reading it.
What kind of friends do you have, Josh? No, just kidding.
Are you gonna blame it on your partner that the book is in your house? Someone saw it.
I actually am gonna blame it on him. He may have been the person who bought it for me. I've started reading it, and I think they make a compelling case that there were errors by the media in the CanLII story, but there are also parts I've read where people do seem to be making excuses about, the people in residential schools. They had the best of intentions, and that may have been
they had a pool. That was the famous.
They had a pool in CanLII.
No, at one of the residential schools, there was one of these people, I forget who it was. I think it was Tom Flanagan with a few other people who wrote an article for True North a few years ago saying they overlooked the fact that the residential school had an impressive pool. It's like, last I checked, ripping your child away from their Indigenous culture and their parents can't be remedied by giving them a nice
Someone
pool.
took my son without my permission and took him away from me, it would not, like, the fact that the place that they were making him live had a pool would not make that better. I think we can condemn the notion of residential schools, and we should, but I think it's I just don't know how many times as a society, as many societies have repeatedly learned the lesson that banning books and condemning books is the wrong approach. It actually makes people want to read the book more, for one thing. But for another, if you just outright ban something, you say this is the forbidden thing, in addition to making people want it more, you don't actually engage with the ideas. If the ideas in the book are bad and wrong, as Josh is reading it, he's offering criticism of what the problems are with some of the arguments in the book. So that is the correct approach. We've learned this many, many times, that forbidding something is not the right solution. But let's take a break now. And then when we come back, I will give you my headline and we'll get to our bad legal takes. Is my Wi-Fi okay, guys?
Yeah, you sound good.
Okay.
You're all good.
Sometimes it goes a little weird. Okay. Okay, so now I want to give you my news headline, which is about a case from Saskatchewan that just got leave to the Supreme Court, and it's called R and Singer, or the King and Singer, and it's about unreasonable searches by police. So in this case, the background is that the RCMP had received a complaint about a drunk driver in a speeding truck. Someone had called in a tip, and the police went, looking around, and they found the truck at midnight sitting on a driveway with its headlights on and its engine running. So they had no idea whose house this was. As it turns out, it was Mr. Singer's. So they walked up to the driveway, and Mr. Singer was inside the truck, and he was behind the wheel, seemingly unconscious, and slumped over towards the passenger seat. And the police knock on the window. He doesn't wake up. So they open the truck doors, and they say that they immediately detect a strong odor of alcohol. The police shake Mr. Singer until he wakes up, and they ask him to take a roadside breath test, which he fails. So then he's charged and taken to the RCMP station, where he then refuses to provide a breath sample and is charged with refusing to comply, in addition to the charge of having care and control of a vehicle while impaired. So the question that is now going to the Supreme Court is whether the police were allowed to walk up to the driveway to investigate the complaint. And the trial court found that Singer did not have a reasonable expectation of privacy, so there was no violation of his right to be free from an unreasonable search. But the Saskatchewan Court of Appeal disagreed, and they said that Singer's Section 8 right to be free from an unreasonable search, it was violated when the police walked onto his driveway. And the Court of Appeal also said that admitting the evidence from that search, namely that he was, the condition they found him in and the breath sample, that it would be, admitting it as evidence would do damage to the administration of justice. So they excluded the evidence from the search. And their reasoning was based on a few things. First, they said Mr. Singer didn't have a reduced expectation of privacy associated, that sometimes is associated with moving vehicles. They said he didn't have that reduced expectation because his vehicle was parked on the driveway of his own home. The court said that there is no implied invitation for the police to approach the door of a residence and observe for signs of intoxication. And they cite some case law, which I'll explain. And they also said there's no implied invitation for the police to enter a driveway and gather evidence from the occupant of the property. They found that the police trespassed the moment they stepped onto the driveway, and they continued to intrude on Mr. Singer's reasonable expectation of privacy. The court said that there were not exigent circumstances or concerns for public safety that would justify that intrusion. And therefore, Mr. Singer had a subjective reasonable expectation of privacy, and that expectation was objectively reasonable, and the police infringed on his right to be secure from an unreasonable search. So now the Supreme Court will consider that question. Does a driver of a vehicle parked in the driveway of a dwelling house have a privacy interest protected by Section 8 of the Charter? Does that privacy interest mean that police officers responding to a complaint of impaired drivers cannot approach the vehicle and communicate with the driver and observe for signs of impairment? So there is something called the implied license to knock doctrine, which means that police can approach a home to knock on the door to communicate with the person inside, and that this is not a search or an unreasonable one. So the difficulty arises, though, when police use the license to knock the implied license to knock as a pretext to collect evidence. And there are some cases dealing with this and the limits of the implied license to knock. And those cases are Evans is the Supreme Court case, and then there's a Saskatchewan Court of Appeal case called Rogers. And in Evans, the police conducted an investigation into residential marijuana, a grow op. And the way they did this was by walking up to the residence of a door, Mr. Evans' door, with the intent of sniffing when he opened the door, of like seeing if they could smell marijuana. So when they knocked and Mr. Evans did open the door and they did smell the marijuana, and then they arrested him. So the question in that case was whether or not sniffing for marijuana at Evans' door was a search, and if so, whether it was reasonable. And in Evans, the court held that it was a search and it exceeded the terms of the implied waiver, and it was an unreasonable search. Although in the end, the evidence in that case was still admitted. And that rule from the Evans case was expanded in Saskatchewan in a case called Rogers. And in that case, Rogers, a police officer went to a home of a registered vehicle owner who had been involved in an accident. So there was an accident. They found where the vehicle in the accident was registered. They went to his home. They knocked on the door, and it was Mr. Rogers who opened the door. And when he talked to the officers, he was slurring his speech. When he walked to show them his vehicle, he was staggering and stumbling. So they arrested him. They took his blood alcohol, and it was above the limit. So the Court of Appeal in that case, in Rogers, found the right that this violated Mr. Rogers' right to be free from an unreasonable search and seizure. And the court sort of had expanded on the Evans reasoning to conclude that when a police officer knocks on the door of a residence for the purpose of securing evidence against the person inside, the officer is conducting a search within the meaning of Section 8. So the court interpreted Evans as standing for the principle that exceeding the authority conferred by the implied license to knock constitutes a search. So back when Rogers was decided, the Saskatchewan government tried to appeal it, but they couldn't. Leave was denied. So they think that the decision in Rogers is wrong. Their view is that it's an unreasonable expansion of the Evans decision, and that this case, Singer, would take that expansion even further. They view this case and Rogers as a misapplication of the principle in Evans, and they want to correct it. And I read the decision. Look, I have not actually thought through this enough to have a crystallized view yet. I just read it when this decision got leave. But what I would say is that this case presents some of the same challenges that when you're engaging with the public and garnering public support for a cause, even as a civil liberties organization like ours, the problem you always encounter with a Section 8 case is by the time we're fighting over Section 8 about what was discovered in the search, we know what was discovered in the search, and it usually is something bad, because that's why you're fighting over the admission of the evidence. So we know that Singer was impaired and that he was behind the wheel. And it almost always comes down to, in these cases, someone who we know did something wrong, and then there's a fight about whether to exclude or admit the evidence. So these cases are often difficult to get public support for, because we kind of know what happened, even though as a civil liberties organization, we know how important it is to be free from the right we know how important it is to have the right to be free from an unreasonable search. If we didn't have this right to be free from unreasonable searches, police would conduct themselves in really bad and inappropriate ways. So there's always a challenge in these privacy cases over getting the public on your side, even though I think the principles at stake are really interesting here. Joanna, you were a criminal defense lawyer, so I'm sure you've seen all kinds of misconduct in police searches. What's your kind of view on this public support issue? Because we know what happened. How do you convince people about the right, as a general principle, that the right to be free from an unreasonable search is important, when we know in these cases that the person had done something bad?
Well, it's about how the system is, and it's about what we want to be proper police procedures. Like, if you think that the boundary of your driveway is your private property, which it probably is, then you have to reconstruct all of these steps where the person was innocent. And if you're parked in your car, do you think it's appropriate where the police, there's at that point, they couldn't smell alcohol. They do have some reasonable suspicion based on the license plate, but is it an acceptable thing for cops to just knock on your car door and roll down your window when you've already kind of made it home free? And there's a bunch of cases from like the early 90s when the Supreme Court was really disciplined about this stuff, where it's the sort of happenstance circumstance where cops are being sort of sloppy and they end up ordering an illegal search. And oh, there's like a ton of marijuana there. And clearly the person's a drug trafficker. And the Supreme Court used to be very, very disciplined about these things. And because all of these decisions very clearly and immediately are operationalized by cops in what they can and cannot do. So I think it's an interesting issue. I'm not sure if the issue of the driveway has come up. I guess presumably if it hasn't, if it's going to the Supreme Court. So we'll watch it. We don't know quite what position we'll take or if we are going to get involved in this case. But I think you have to look at this, all of these decisions, because what happened with Singer has happened. You have to look at it as how it's going to be operationalized and used by cops in their guidebooks and used in ways that are going to further intrude with our privacy rights. What do you think, Josh?
Yeah, I agree with all that. I think what people don't understand in these cases is that it's not about Singer, it's not about this particular guy. It's about whether we want police to be able to do this type of thing on a regular basis. Because if they can say, well, there's some sort of implied license for me to just like walk up and question people sitting in their cars in their own driveway, cops are going to do that, and they're going to do it all the time to innocent people. And it's not about preventing the unreasonable search of someone who turns out to be guilty. It's about the fact that we don't want the government to have that blanket power to, search us. And if you think about where the right sort of originated, it originated in the UK because there were journalists that were publishing things that were considered offensive to the king and to the king's appointees. And so the king would send henchmen to like go into people's houses and search for copies of the newspaper and try and figure out who was writing these anonymous articles that were very much in the public interest about the king's behavior and things like that. And in the US it emerged because tax collectors would just they had trouble getting people to pay their taxes, so they'd just go search through merchants' houses and try and figure out like who's not paying their customs duties. And when you do that in both cases, first of all, your people can't, get together and print a newspaper that's critical of the king or Justin Trudeau or Doug Ford or whoever, if the state can just go into your house and search it and try and like, rustle through your things and intimidate you. And the same thing with the tax collectors. If they can just go through your house anytime, you have no autonomous sphere to like sort of fight back against them. So I like pretty clear lines on this stuff. And I think property is property, and there needs to be some sort of, whether it's reasonable suspicion or a higher standard, there has to be something here before police can just do that sort of thing. So, like both of you haven't thought all that much through this case, but it's something we definitely need to dig into and think some more about. So with that, I think we should move on to our bad legal takes, and I'll go first. Mine's pretty quick. So mine goes to Vasanthi Venkatesh, who is a professor at the University of Windsor's Law School, who teaches about social movements, immigration, labor law, and, quote, law and resistance, whatever that means. They didn't offer that course when I was in law school. She had basically the most out-of-touch tweet, I think, that I saw among many tweets during the hearing of last week's U of T injunction motion. So during the hearing, rather than focusing all that much on the law, one of the lawyers spent a lot of her time walking through the history of social movements, mostly in other countries, and she concluded by claiming that, if granted, this injunction would be, quote, an extraordinary intrusion on freedom of assembly. And this lawyer oddly refused to answer the judge's questions, saying that was, quote, his job, and she chided him for making what she called a slippery slope argument. And Christine and I were both kind of laughing at that, because it's like, no, your job when you're in court is to answer the judge's questions. So anyway, this lawyer concluded her submissions by playing a recording of students on campus reading a poem by the Palestinian poet Rafat al-Arir. And this poem is called If I Must Die. It's kind of like a viral Twitter poem, very sad. But Nenkatish really liked this approach to lawyering, apparently, and she tweeted that the hearing was, quote, fire emoji, or she used the fire emoji, which is Gen Z for, amazing or really good. And she wrote, Counsel played Rafat's poem in court. Palestinian advocacy is showing that lawyering is not just about arguing about technocratic technicalities and liberal ethics, but can be subversive by centering the community's radical justice discourse. And as I pointed out at the time, spending your extremely limited time in court reading poems may be subversive and centering the community's radical justice discourse, but it's probably not going to go over all that well with a judge who has to make a decision that is legally correct based on applying centuries of case law to the facts at hand in a way that's not going to be overturned on appeal. And it turns out I was right about that because, as we know, the injunction was granted, and granted thanks to U of T's lawyers walking the judge through all of the relevant case law in a way that he could do nothing other than side with them. So my bad legal take goes to all the people who think that reading poetry in court is somehow a good approach to making legal arguments. Christine, let's do your bad legal take.
Josh, I think that you just made this your bad legal take because you're trying to get out of having to rhyme all of your advocacy in the future. I was gonna ask you to put some poetry into the next factum.
Yeah, that's not happening.
Okay, so my bad legal take goes to Dennis on Twitter. Here's the context. So there was a news story about the Trudeau government's incoming clean electricity regulations, and the Saskatchewan government believes that these regulations are unconstitutional, and they have said that they will not comply with the regulations, to which Dennis on Twitter said the following: the Supreme Court of Canada defines sedition as any practice that is calculated to disturb the tranquility of the state and lead ignorant persons to subvert the government and laws of the empire. Seditious words and libel and conspiracy are punishable by up to 14 years in prison. So I think that he's suggesting that Saskatchewan needs to be punished with sedition for not wanting to comply with the Trudeau government's clean electricity regulations. So this is a quote from the 1950 Supreme Court case of Boucher and the King. But look, two levels of government disagreeing with one another about the constitutionality of a law is not sedition. It's not even that abnormal. There have been many instances where provincial governments had said they will not comply with a federal law that they believe is unconstitutional, and they've gone to court to successfully challenge those laws. There's, for example, a lot of debate over the Alberta Sovereignty Act. There was a Quebec case we were involved in about the question of whether or not that province, Quebec, can refuse to implement federal law. This is not sedition, and it's not even unusual. And I actually think that this tweet was kind of an interesting segue into the debate happening in the United States right now over executive immunity for official acts. So Dennis seems to really want premiers criminally charged for disagreeing with the prime minister. I frankly wonder if he would change his tune if the partisan identity changed. For example, if it was a Liberal or NDP premier disagreeing with a conservative prime minister, I suspect that it would. And that means that your argument is probably not based on reason or principle. It's just you don't like the person involved. Joanna, how about your bad legal take?
So my bad legal take goes to the legend and lady herself, Barbara Streisand, who tweeted out this week, the Supreme Court overturned 40 years of precedent and overturned the Chevron decision. The Supreme Court of the US, of course, makes judges and the Supreme Court the regulators of laws passed by Congress rather than the scientific expertise at federal agencies. This is not democracy, but rule by judicial order. The only beneficiaries are big business and polluters. So, of course, there's this rallying cry of specialized expertise. So just a bit of background, this was a decision that required courts to give extraordinary deference to administrative agencies. And it is true that some of them do have technical expertise. And by the way, the overturning of Chevron does not mean that their expertise is irrelevant. The court made it clear that quote unquote Skidmore deference, which is specifically tied to technical expertise, will be preserved. But bigger picture, we know, and this is where Babs, I'm sorry, you have a bad legal take. Expertise is by far not the only factor which influences the decisions of administrative decision makers. Partisan and ideological biases also have a big impact because administrative decision makers are appointed by the executive. And furthermore, the decisions that these decision makers are making are very rarely just based on value neutral technical facts. They have to do with competing values. And so the concern with Chevron deference, which was well articulated by SCOTUS last week, is that you need somebody that actually has expertise in law and constitutional law. So I think that, first of all, there's a lot of hysteria, which Barbara has certainly fed into. And second of all, the notion that concentrating executive power by allowing them to completely delegate the administrative state and effectively eviscerating judicial overview is good for big business. It's quite the opposite. So sorry, Barbara, we love you, but bad legal take.
I don't love Barbara. Just putting that out there. All right, as usual, we hope you'll rate us, review us, and subscribe. And you can support our work by subscribing to the CCF's YouTube channel, by following us on Twitter, or by visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by donations, so please click that donate button on our website if you can. Thanks for listening.